What's up? It's your boy Kevin to turn on this motherfucking YouTube shit. Wow, what the fuck?
What's up? It's your boy Kevin to turn on YouTube shit. Hey man, we are literally cheese man, turn. Say, motherfuckers, they hear us our big crib in the gang shit in that session, man. Free Palestine, free Congo, turn up Russia, do your thing, Texas, turn up. Anything today to be a better version of yourself. Never let's not bring down, step back. Never let's not tell you are boss and put yourself in a position to belong. Let's stay humble. The only revolution. Keep y'all way first. Come to the Black Hebrew Israelite. As a real Jew, we out here on these streets, man. Let's get out here, man. Alright. Boom. Okay? It's a motherfucking day. Straight out some big crib in the gang. Straight out that shit, man. Alright, gang, man. So we out here on these streets, gang. You know what I'm saying? Turn up out here. Turn up. Y&W Melly, man. You know what I'm saying? You know, he be in this bit, man, doing his thing, man. You know what I'm saying? Holding it down out you. You know what I'm saying? These motherfucking things, man. You know what I'm saying? Hopefully he get free from it. You know what I'm saying? So y'all know he got these charges that's been kind of fucking up. You know what I'm saying? So we go to one of his court cases. You dig what I'm saying? And this is, I guess, basically, I'm gonna sum it down, Crip. It's like a witness tampering, like a case. You know what I'm saying? That his girl, at that time, they trying to say that he whoop-de-whoop tampering type shit, and that his lawyer is trying to get an extra charge for trying to take out the damn the witness, and then again, like, if he get this charge, it might be another charge, and then, like, he beat this case, it might be another case, he might have to do life. This shit is getting crazy. So we got a whole video, man. This is basically the court that I'm trying to explain it through that shit, Crip, but you know what I'm saying? Hey, we out here. Alright, let's get to it. Alright, gang, you know what I'm saying? So let's see about the Y&W Melly case, man. Hey, we been at this motherfucker for a minute, no cap, nigga, like, fuck. But hey, you know, it's been going on this long, it's still faith that, hey, he get released in this bit, you know what I'm saying? And we be up and stuck out here, you know what I'm saying? But hey, you gotta keep on having faith and just, hey, see how this stuff going. And I don't know what they talking about. People snapping, turning up in that bit. Like, what's going on? Hey, you know when you start to get closer to your release date or just good things, shit gonna happen. Let's see what's going on. Turn up.
They want to kill my client. That's what we're playing with, his wife.
Huh? Oh man, wait, what?
Let's get the death penalty for Tamperin.
Yeah, but they want like
Bradley's testimony in the murder case is wholly irrelevant. So,
bro, this is wild.
We're talking about the Tamperin case. We're talking about
we are talking about the tampering, but they're also intermingled with each other. So it's life in prison for this tampering.
A motions hearing for many true crime watchers sometimes can be a snooze fest, but not this Y&W Melly hearing.
So what has happened in the past is that she has asked for dates. We provide dates, and then she schedules dates or times outside of those.
Judge, he's actually lying to the court right now. I've printed out every email.
Please, stop.
The judge overseeing Y&W Melly's retrial is telling the state to hurry up and move the case forward.
So in case I'm not making my feelings at this point
What
clear,
y'all do? Fuck him up.
but talking
I mean, that's meant my help, Y&W Melly. You know what I'm saying?
Absurd. I'm embarrassed on both sides. I'm embarrassed.
But the true fireworks came from Melly's lead defense attorney.
And now, 2 years later, I'm being accused of trying to kill Daddy Polo. I don't know exactly because we don't know affidavits with his
So she found Wanda and Melly?
Picture, and I'm directing gang activity. I think at this point, Detective Polo is in need of an evaluation to determine if he even has the capacity to.
Jamel Dimmons, aka YNW Melly, has been locked up in jail for 6 years, despite not being
about 6
convicted of a
years.
crime. I'm Elizabeth Milner for Law and Crime. As you just heard, the judge in Melly's case says he's embarrassed for both the prosecution and the defense. Plus, you might be wondering, why is Melly's attorney saying a detective needs a mental evaluation? So let's unpack it all, and it's a lot. During this week's court hearing, Melly didn't appear in the best spirits for another motions hearing. He's been locked up since February of 2019. 6 years now, despite not being convicted of a crime. At this point, we all know he was tried, but his first trial ended in a mistrial. That was in 2023. Since his trial has been pushed back and back and back, but he's expected to be retried in September of this year. While both sides are prepping for his highly anticipated retrial, they still continue to hammer out motions, mainly from the defense's side.
There's 8 motions. Number 1.
So why are they really trying to get it over with, and they keep on pushing it back?
Violation. Court dated February 9, 2024. 2. Motion limited to exclude James Howard's irrelevant and immaterial detention communication calls. 3. Motion limited to exclude
cats and dogs out here.
TikTok video of meeting page. 4. Renewed motion to take deposition of Christine Brad. 5. Defendant's motion to strike from the alternative response to the state of Florida's motion to allow former testimony of Felicia Holmes. 6. Motion for scheduling. 7. Amended third motion to compel forensic images of proceedings following. And 8. Motion to compel. So that's what I wanted to get done today.
So here's the thing. The defense was ready to argue their motions, but the drama started when the state said they didn't meet their deadline, and Melly's lead attorney, Raven Liberty, wasn't having it.
Judge, the other issue we have, and I wasn't present for the hearing Friday afternoon, but my understanding was the court set a notice of hearing deadline for Friday 5 p.m. It was moved to Friday 9 p.m. because Ms. Liberty was stuck in court and needed time to prepare it. The notice was not actually filed until Saturday, so they failed to comply with the court's requirements. So at this point, the state's position is no notice of hearing was properly filed, and there's nothing to be heard today.
So you won't be doing it.
This also in light of the fact that this button was not available.
Okay. Ms. Liberty, what do you want me to do?
The funny thing is, the great thing about this cameras in this room is everything is recorded. I did say Friday at 9, and then
Okay, that's the same lady.
For failure, and I do it Saturday. Taylor didn't respond to this comment. Oh, as long as we get it before the beginning of the next business day, which is Monday. So they've had it. Most of these motions, Judge, were filed for over a year. I will bring the court's attention because last night in preparation of this, I know the last time we were before, they objected then about hearing motions because they were filed under the Tamperin case. Yet they've filed several different motions saying it doesn't matter what case number are on the motions because the discovery is interchangeable. I'm quoting exactly the language from their own motion. So it's good for them when it's convenient, and now it's not convenient, so there's another excuse. It's been a year. Everything was properly noticed. I will also add, there's no written order setting a filing deadline or allowing them to file a response within a certain time frame. That was oral. So as we all know, oral orders don't count for anything. They need to be written. There was no written order. I did ask to extend it. We are ready to go forward. There are 2 state attorneys sitting over there. Understandable. One of them's missing. Mr. Griffiths, is there something funny?
The lead attorney is missing.
Ms. Liberty, you can direct your comments.
Okay.
All right, y'all are around here to talk to each other about this.
We're ready to go for a judge.
Okay.
The first motion was pushed to another hearing for more time. The second one had to deal with Melly's witness tampering charge. So back in the fall of 2023, after Melly's first trial ended in a mistrial, Broward County Detective Danny Polo, who also testified in his first trial, was investigating a blood member held at the jail. But what does that have to do with Melly? Well, Detective Polo was monitoring that reported blood member James Howard's recorded phone calls and heard him talking about passing messages to Melly. Then Detective Polo later uncovered hundreds of phone calls between James Howard, Melly's ex-girlfriend Mariah, Melly's manager, Jamison Francois, and Melly's co-defendant, Cortland Henry. Now, the state wants those phone calls to be admitted for retrial.
But is that bad?
Every cat.
Why the defense doesn't.
Was they saying anything?
Addin's motion in limine to exclude James Howard's irrelevant and immaterial
Damn.
communications.
Who the fuck
So
does
you're talking
that?
about the motion limited for trial. I read the motion. Anything else you want to tell me in support of your
So they're trying to push the court date back to, so they get the other stuff off the phone call. They said, nah, nigga, we gonna get this shit over with. What y'all talking about? Damn.
I was always a position it was given to us late in the game in order to make it continue it. Nonetheless,
And they couldn't have been talking about shit. You know what I'm saying? They could have been talking all on the phone.
Along with myself and the investigator. When you look at the police report that was authored by Garrett Steele, it starts referencing an investigation that's being done by Danny Polo into this James Howard, and I believe the all the game. He, for some reason, then references James Howard in this police report, saying he was listening to phone calls by James Howard, and then he hears James Howard telling somebody on the phone call that he has to do something for Melly that day. That we had the opportunity to depose Detective Polo as well. I asked him this very question. I told him over radio hours with the phone calls. There was one phone call, and that one phone call in this batch of phone calls tells us nothing other than him saying, oh, I have to talk to Melly today. Not I have to do something for him, not I gotta call people for him, nothing at all. During the deposition of Detective Polo, when I started questioning him, hey, I went through all these phone calls, could you please direct me to what phone call I should be looking at? What batch of phone calls? He then tells me, it's not this batch of phone calls. It's a batch of phone calls that would go back to 2020 and 2021. We are dealing with the tampering. I believe we're spanning from April of 2023 until August of 2023, somewhere in that time frame. Detective Colin's own words was the only time that he has heard James Howard talking about Melly would have predated the incident, i.e. 2020, 2021. Nonetheless, those phone calls are not in this 84 hours of phone calls.
So they're trying to say the phone calls don't mean nothing.
Judge, before we proceed on that, there is still the outstanding issue whether Mr. Kevin still wants to consider representing him. The state has raised the issue with the conflict of interest, and the court pointed that out. That was going to be one of the first things we were going to address today, and we still need to address that because obviously he is not long considered representing him, then there's an issue that can be argued.
I mean, that's his call. I already had that discussion. I'm sure if there's something that you want to let me know, you're going to let me know.
If you're wondering about that exchange, last month it was revealed Raven Liberty was under investigation for allegations of witness tampering too. More on that in a few, but let's get back to the motion.
Any response to the motion?
Yes, Judge. State filed a written response. I believe it was yesterday. This is one that Ms. Kwakalu prepared, but as pointed out in the argument, that the state is not required to disclose which calls it intends to use at trial. But other than that, we are going to rely on the response that's written.
So I did check the docket this morning. I saw no written motion. And it's funny, Judge, that they were starting this hearing off saying they wanted to continue it because they didn't get proper notice of a notice of hearing from, I don't know, almost 2 weeks ago. But in the evening, they filed something before Ms. Buckley went to the hospital.
This is the second time.
So why ain't the Melly people like, let's go and get this over with? They trying to continue because they trying to look for other shit.
Okay, my apologies.
Damn, bitch.
No, Judge, I would say there are no.
This whole trial been crazy, man. I was like,
witness number.
I ain't gonna cap.
So, this is one, and I'll enter the appropriate order is going to be denied without prejudice. I have no idea what is or what is not going to be relevant. And without giving the evidence at trial, there's no way that I could.
Like, this is the retrial, you know what I'm saying? Like, you did, kid. Like,
raise the issue. The state tries to introduce any of these phone calls at trial. Give the appropriate objection, and I'll give you the appropriate ruling. But in a vacuum, having never heard any of these calls, I have no idea what the calls are, nor do I have any idea what the evidence is going to be in the trial.
So they going to do about the jury trial? Is that what this is
A
again?
familiar name was brought up in one of the following motions.
Number 4.
Ain't that bitch got kicked out, didn't she?
I did read the motion.
But she was wildin'.
say Judge Murphy had already entered that order, which I attached December 18th. And it says, after such emails are reviewed, if defendant still wishes to depose ASA Bradley, counsel shall file a written motion.
Were you recently injured in a car?
Following this case closely, you know who Christine Bradley is. She was the lead prosecutor in Melly's first trial, but she was thrown off the case months after Melly's mistrial. Why? Well, it's a long story, but to make it quick, another Broward County State Attorney, Michelle Boudreaux, came forward and testified she overheard the lead investigator, Mark Beretti, ask a deputy to lie about being present during a search warrant for Melly's mom's phone back in October of 2022, months before his first trial. That information wasn't turned over to the defense until after his mistrial. Now, Christine Bradley fits into all of this because she said the exchange was a joke, but ultimately Judge Murphy, who oversaw Melly's first trial, out of an abundance of caution because the defense might use her as a witness in Melly's retrial to discredit lead investigator Mark Beretti. Now, fast forward nearly 2 years later, the defense wants to depose her.
So I did that, I think, sometime in February, close to a year ago. I wrote it out. At this point, we need to depose her, especially in light of all the things that have came up. I went through and I amended this motion to add a few other things that had happened in the deposition, i.e. these emails. They get even more confusing. Your lead detective on this case, Garrett Steele, said under oath that he never read these emails. These emails are referenced throughout the affidavit and the arrest, stating that the deposition and these emails prove there was an official proceeding that Mariah Hamilton did not go to. Again, Garrett Steele said he never read the emails. Danny Polo then says it's not his case and he can't comment on the emails. It's really unclear from reading them what's happening. And again, there were certain emails that were not even provided by the state that we later were given from other sources.
Okay, state.
So they're saying it's not
first,
important.
that's an inaccurate statement. The emails were actually provided. That's actually in the state's response to one of Ms. Liberty's other motions, but turning specifically this one, the state filed a response back on January 2nd of 2024, and we're relying on that response.
So, Judge, the rules provide I can take depositions of anybody.
So I guess you trying to say, nah, go and get them bitches out.
Information, which Ms. Bradley is listed or not listed. Because they filed a protective order and won't allow me to do it. That's why I had to then file the first motion.
All right, so Mr. Grips, I'm looking at 3.220, subsection H, discovery depositions, and this is 1A. The defendant may, without leave order, take the deposition of any witness listed by a prosecutor as a category of witness or listed by a co-defendant as a witness to be called at a joint trial hearing. That's not Ms. Bradley in this case. Correct. But then the next sentence says, after receipt by the defendant of the discovery exhibit, the defendant may, again, without leave of court, take the deposition of any unlisted witness who may have information relevant to the offense charged. So don't they get to take her deposition?
Except for the fact that, Judge, she is a state attorney. In her role as state attorney, she's entitled to certain protections. We filed a protective order, in part because everything that Ms. Liberty is asking for has been turned over. The emails, whatever else that she's been looking for, has been turned over, I believe, actually several times by Ms. Buckaloo, again, which is one of the issues going forward today.
So they gave her her
her here, but she was the one that provided copies of everything.
Well, she's not assistant state attorney assigned in this case.
Ms. Bradley? No, but she's still, it's no different than if somebody is a case filer or works on a case. There are work product protections involved in terms of what Ms. Liberty intends to ask, and we sought that protective order because she's entitled to those protections as a prosecutor, and also because, based upon our response, that it is unnecessary.
So she filed a protection order.
Someone grant the protective order?
I believe that was a hearing that Mr. Klinger conducted back in like November of last year, but I was not party to that.
So
she filed protection on Crip. She like they couldn't give it up then.
On December 18th. And then Ms. Buckaloo was ordered to provide emails, and if I was not satisfied, as that order clearly states, write the motion so I could depose her. So I've written the motion. I am looking at what she provided.
That's where Ms. Liberty, I'm still not following what the relevance is. Tell me
then, like,
let's say she wrote
what they gained.
1,000 emails back and forth between the witnesses. What is the relevance?
Because if you go to the arrest affidavit, under the witness tampering. These emails that Ms. Bradley authored are specifically referenced in Garrett Steele's police report, right? He says that he reviewed emails between Christine Bradley and defense counsel coordinating the deposition of Mariah Hamilton, that she showed her numerous attempts to get Mariah Hamilton to this deposition. That is Garrett Steele's words. We deposed him. I put it in the motion. Garrett Steele then says, I never read a single email. I'm depending on it.
His report's not going to be in front of the jury. I mean, none of that's going to be in front of the jury.
I know, Judge, but when I'm moving to set up every element of this witness tampering case, that seems more and more that it was filed out of being vindictive, more so than anything else. It is relevant to these emails because it is part and parcel of everything of the basis of arresting Mr. Demmons. They weren't saying Mariah Hamilton didn't show up to trial. They said Mariah Hamilton didn't show up to a deposition. The other reason I need to depose Christine Bradley, because it's really important how that May 5th date was given. All right?
So they trying to take her out the whole damn court. Like, she's not even in court in this bitch.
Your life is your choice.
We need to hear from Christine Bradley and find out what efforts she made to coordinate this deposition with Christopher Barris. That is why she was also supposed to turn over these emails. And guess what? When you read these emails that get turned over, Stuart Adelstein's emailing with Miss Bradley, trying to ask for dates for the deposition. There was not one single email that was provided to us in Ms. Buckley's response from the time that Christine Bradley gets us dates to the time that Stuart picks up. She was not contacting Mr. Barris. We can't see that at all from her emails. We finally get an email from her April 18th that's copying an email from April 17th. That appears to be the first email that she sent to Christopher Barris about this deposition. So for the state to not coordinate a deposition with a witness and then to cover up their negligence, turn around and file a criminal charge against the defendant, when in reality, if we got her up there, we would hear from Miss Bradley that she never properly coordinated this deposition, that she never told Christopher Barris. And all the months leading up to us trying to schedule this, Mr. Barris, from these emails, was never contacted. And that's what we need to depose her about, the efforts that were made from her.
The judge's ruling was another blow to the defense. Well, depends on how you look at it.
They want to kill my client. That's what we're playing with, his life.
Stop, please. You just told me to
Damn.
Let's get the death penalty for the tampering case.
Yeah, but they want
Ms. Bradley's testimony in the murder case is wholly irrelevant. So,
they want
let's go back. Are we talking about the tampering case, or are we talking about the...
We are talking about the tampering, but they're also intermingled with each other. So
okay, they said no, they said they trying to kill damn Ryan Millie because they trying to say he's tampering with the evidence.
I'll take the appropriate written order. I don't find that her testimony is relevant in any way, shape, or form. It's not relevant in a homicide case, nor do I find that it's necessary under what's
they trying to say that she don't even have to do with Ryan Millie tampering. But they trying to say they looked at evidence and found some shit. But they looked at evidence and found out they was talking to them people the whole damn time.
Melly's been locked up for 6 years, not even convicted. Well, the judge is pushing prosecutors to move the case forward. Essentially, hurry up.
I consider this more of a professional courtesy if the parties want to be courteous to each other.
So they're trying to say that they're trying to use her tampering with Wanda Millie, but they trying to say that we looked at the damn evidence and we don't find shit. But what we do find is she talking to them motherfuckers about trying to get them motherfuckers out the paint.
One state attorney's not available, maybe one of the other two assigned to this case can stand in. And if all three are not available, maybe one of the other 150 state attorneys upstairs might be able to sit in, but you don't have to wait on that. So.
Thank you so much, Judge.
I mean, just so you're clear, you're not advising Ms. Liberty unilaterally set the motion.
No, it's not unilateral. She can coordinate. If I'm getting, I read the motion. She says she's, I have one state attorney who can tell me he's working 1 day a week here. Is that right? So that's That's 80% of the time is off the table, and just being told that they can't show these depots and won't do it. You don't have to wait. Set the depots, subpoena the witnesses, and if someone doesn't answer a subpoena, file the appropriate motion, and I'll conduct an indirect criminal contempt proceedings. But it's time to move forward.
We are moving forward, Judge, but we also, the other issue it's been is that this liberty must properly.
I guess the judge don't really give a fuck.
Notice the state. This is a requirement. I know, but
I just read the rule. She doesn't have to coordinate anything. She has to make a good faith effort.
Right. She has to make an effort.
She has to put a certificate on the bottom that says, "So I tried. They told me no."
So what has happened in the past is she has asked for dates. We provide dates, and then she schedules dates out or times outside of those.
Judge, he's actually lying to the court right now. I sent out every email.
Please, stop. She's gonna set her deadlines. She has to put a certificate of good faith on the bottom. If you all feel that that has been submitted in error, you file the appropriate motion, and then what would be a wonderful use of this court's time is I'll have a hearing with 6 lawyers, 7 lawyers, because you all can't say no. So in case I'm not making my feelings on this point clear, I'm not prejudging anything, but talking to a judge about trying to agree to set depots in a death penalty case is absurd. I'm embarrassing for both sides. I'm embarrassed. The motion for scheduling order is denied. You don't need a scheduling order. Set your depot. I'll enter the appropriate written order.
Yeah, that back and forth between the state and the defense definitely seems to be annoying the judge. Now, for motion number 7, the defense wanted the forensic images of the victims' phones.
I think the issue that Ms. Bucklew had, and I'm probably going to be speaking out of turn on this one, is that there are contents of the phones that are not relevant to the case. And so some items have been turned over, but not all the items. But unfortunately, this is one where I am lacking of knowledge.
That's okay. The state doesn't get to decide what's relevant and what's not relevant. These are the homicide victims, right?
Yes.
Need prescription eyewear fast? I buy direct.
Well, Judge, I can tell you because I took part of it. It's not necessarily that we have to turn it over. We have to make it available for inspection. We did on a number of dates. We scheduled that. We told them they can come again. There were multiple days where we sat there and waited for their investigator, came hours late. She's going again. So I'm going to,
if I may finish, Your Honor. I was the one who was personally there that day with him and our investigator. We continue. Anytime they want to come see it, we have had an investigator from our office, the computer, and their investigator there to sit down and go through it anytime they want.
Stick a thumb drive in and download what you got, and that's it?
Make a copy of it? No, Your Honor.
They're withholding
Why
it.
can't they do it?
As Mr. Griffith said, Ms. Bucklew is the one with the most knowledge of all the contents of the phone, and that's why it's all discussed in her response. But regardless, the state's obligation to make it available. We have and continue to anytime that they want to schedule for inspection. If it's available to be copied. Ms. Bucklew, and that's why, again, this is one of the motions we said that she would be prepared to argue, is of the opinion, and she filed the whole. Exactly, right.
And it was withheld there.
Yes.
This is the decedent's cell phone. Okay, over the state's objection, this motion is granted in full. Make the appointment, go over there, download everything that they have.
Now, the final few moments of this hearing finally gave us the answer as to why Melly's attorney, Raven Liberty, was under investigation by the Broward County Sheriff's Office, and her request to the judge was interesting, to say the least.
In light of these allegations that I guess trying to murder or take a hit out on Danny Polo.
Then she on an investigation? Like, what the
Danny
fuck?
Polo might be suffering from some type of mental illness.
This is going crazy.
Heard in the last round that somebody had a hit out on him. He had lied to the court. He found out he had pictures out there in the public domain. And now, 2 years later, I'm being accused of trying to kill Danny Polo. I don't know exactly.
Yeah, they're trying to say she tried to take somebody out. What the fuck going on?
And I'm directing gang activity. I think at this point, the next goal is I need an evaluation to determine if he even has the capacity to sit and testify in this case or any other case, because he has some type of paranoia about being murdered at this point. He's actually going at a defense attorney, saying a defense attorney is trying to murder him now, because that is the premise of this so-called investigation, is I'm trying to kill Danny Polo.
So you see trying to say they making that shit up. Man, this is wild motherfucker shit. But ain't she fighting for one day, Melly? So I mean,
is that he undergoes a psych evaluation
This shit
before he's
crazy.
allowed to testify further in this case.
I think, because I don't entertain or attend motions, but I think you're talking about challenging the competency of the witness, correct?
Yes.
Okay, so I think if you have that concern, I guess you need to file the appropriate written motion.
I hope there been no court lawyer. At least the good ones and shit. I don't know.
It's a pretty strong ask, but it's also a strong allegation. Now, in Melly's first trial, Detective Danny Polo made headlines while donning a black ski mask while he testified as a witness for the state. Now, he worked
Damn,
with gangs, cover, and said he requested to wear the mask to protect his identity. Then a photo of him unmasked went viral. Melly's defense team wanted him to testify unmasked, and the previous judge, John Murphy, sided with the defense and ruled his testimony would continue without the mask. So it's unclear if Detective Danny Polo will be evaluated, and obviously Liberty denies the allegations. But for now, it looks like Melly plans to keep Raymond Liberty on his team. YNW Melly's high-profile retrial is slated for September of this year. If he's convicted, he faces not only life in prison, but also the death penalty. Reporting for Law and Crime, I'm Elizabeth Milner.
Do you live in Texas?
All right, back. So yeah, you get what I'm saying? That shit crazy, dig? But yeah, like I said, man. Hey, when shit happens, you know what I'm saying, and you know your life is based like all over the internet. Sometimes a lot of shit, you be wondering how the fuck did it get to this far? You know what I'm saying? Like, you know what I'm saying? Like, by the grace of God, you dig what I'm saying? Like, I be wondering, like, how, because, you know what I'm saying? A lot of this, like, hey, they almost didn't make the shit if it wasn't for, like, one person. Like, dang, you know, you just really think, like, damn. But yeah, like I said, man, they was trying to say that, hey, that person was basically tampering with the witness or some shit, and they were trying to use that to say that they was trying to take the girl out and all this other shit. Man, I don't know how it got to this point to where it got to witness tampering, bro. You know what I'm saying? I feel like if they made it to a second case, you know what I'm saying? It should just start all back over on the situation. But I know they gonna still, if they start up a whole new case, they just start up a whole new case inside of the case he got going. They could at least wait until he got done out of this case and put that, when he got out of this case, put that on the case. But they said, fuck it, we might as well throw both of the cases in the same thing, fight the same case, same case, the same case. You know what I'm saying? But, and I feel like, man, if Ryan Melly does his thing right, man, I really be thinking about what is he thinking with this damn lawyer. You know what I'm saying? I feel like I'm trying to feel me like Crook. I'm trying to feel like half the time I feel like, is she doing good? Is she doing bad? Is she trying to fight for him? At what point is she trying to really put it, like, you know what I'm saying, really stand her ground on some shit? I really don't see her standing her ground on some shit. You know what I'm saying? I think she haven't made no strong points. She has, like, I feel like when she's talking about this witness tampering, was talking about she gave the papers for all the stuff. I guess they saw what she had. I'm like, okay, like, I don't feel like if she knew the court. This is how I'm trying to get it. She knew the witness. They trying to say. Another lady, she knew the court people who was trying to, like, set them up or some shit, and they try to set this up and that up. I'm like, man, but the judge was kind of agreeing with her a little bit, so that's why I'm like, you feel me? No, I just gotta see how they gonna set the shit up next time, you dig what I'm saying? True. You know what I'm saying? Cause I'm trying to see if it's gonna be good for her, cause I don't even know they start the case yet, because they said they got the information. She trying to say she put on protective order type shit on this shit. You know what I'm saying? I'm trying to see if they, like, you feel me? If they, like, if they gonna get the, like, you feel me? If they gonna try to get the information to try to take to say, hey, we got this whoop and that whoop and. But they said they looked at it and it didn't have nothing to do with YNW Melly. So I'm like, man, I don't fucking know, man. I just feel like, man, if they just Cause they want to speed through it. He said he ain't got that all day. Just go through that bitch. I heard like speed trial is the best type of trial. You know what I'm saying? You take your time. You look. I think you need to speed that bitch up and get to the point, man. You know what I'm saying? So just pass through all that shit, man. You know what I'm saying? Like, hey, you just gotta see how it goes, man. But yeah, man. You know, it's like when they got all your information, all of it. You know, you need to make some shit disappear. I ain't gonna tell you. You feel what I'm saying? You feel me? Like, you know what I'm saying? You come in on your third case. That nigga said, you know how hard they fought for that phone not to come up open? You know what I'm saying? Because the phone had all that. And they said, no, nigga, you can't use that shit. We went past the limitation of what we can do with that shit. I'm like, dang, crap, yeah. They stopped the whole thing because had like a whole bunch of. See, that's what people need, bro. You know what I'm saying? At that time, you know, we just got. He does this on some crazy shit and just to be like, damn, at that time, you're like, nah, you can't do that, bro, because I this and whoop, whoop, and you just pass this, whoop, whoop, that. I can still yo, do, you know what I'm saying? So it's like, hey, like I said, man, this is a good case type of shit, man. We just see what's going on, man. You know what I'm saying? You see a lot of shit, and it bring back a lot of shit. You like, damn, man, why the hell you go up in this bitch and crip, you know what I'm saying? Do his time and still, like, shit, face the death penalty or whatever else he got to do with this bitch, you know what I'm saying? But, hey, that nigga wind up really rock this bitch, man. Hood, Northside, big crip, dang.
Hey, Dad, you know, dog, when we link up, dog, this shit be legendary. You know this instrumental, you the engineer on it, so Kodak everywhere.